Hello friends, in the series on income tax cases, today we will discuss a very unique case which is about the taxability of capital gain in the case of transfer of tenancy rights. The issue before Mumbai ITAT F bench in the present case was that whether the tenancy rights on a building is a capital asset, can the assessee can claim section 54 exemption for the transfer of tenancy rights where the assessee is gaining long-term capital gain? Can the assessee take the view that the tenancy rights cost cannot be determined and hence the long-term capital gain cannot be calculated? Or for the valuation of tenancy rights, the proper course of action is that the matter should be referred to the DVO by the assessing officer. All these issues were determined by the Mumbai ITAT F bench in the case of Chandresh Virvadia versus income tax officer. And this case is reported in 138 ITR Tribunal at page number 36, and the date of the judgment is 25th March 2026. The present case relates to the assessment year 2021. In the present case, the assessee received through the will from his father some tenancy rights. During the financial year which was relevant to the assessment year 2020-21, the assessee transferred these tenancy rights in respect of a property which was situated in a building for a good amount of 7 crore rupees. The assessee calculated the long-term capital gain by taking the fair market value of the tenancy rights as on 1st April 2021 and accordingly calculated the taxable long-term capital gain, and also at the same time calculated the capital gain by taking the exemption under section 54 by saying that the assessee has transferred the tenancy rights in a residential property. When the assessment proceedings were going on, the assessee took two views. First view was that for calculating the capital gain, the fair market value of the tenancy rights as on 1st April 2001 may be taken. And the other stand of the assessee was that since the cost of the tenancy rights cannot be determined and hence the long-term capital gain should not be taxable in my hands. On the contrary, the assessing officer was of the view that in the present case, since the cost of the tenancy rights cannot be determined and the time for referring the matter to the DVO was not there, so the assessing officer calculated the long-term capital gain at a figure of 7 crore without giving any benefit of cost of acquisition or indexed cost of acquisition, and at the same time rejected the claim of the assessee for exemption under section 54 by saying that since the assessee has not transferred the residential property, so section 54 exemption should not be given, and at the same time also declined to give the exemption under section 54F by saying that the conditions for claiming section 54F exemption is not satisfied because the property purchased is in the joint name. When the matter was before the CIT appeal upheld the order of the AO, and when the matter was before the tribunal first of all said that in the present case the rights related in the present case is to an identified immovable property. The tribunal said that in the present case the transfer of tenancy rights are marketable and clearly identifiable. The tribunal was of the view that it is not a case of amorphous or uncertainable intangible rights. Tenancy rights are capable of valuation unlike goodwill. The tribunal said that in the present case there is no doubt that the tenancy right is a capital asset, so capital gain should be calculated, and the tribunal also said that there is no doubt that the cost of tenancy rights can be determined. That cost can be determined by referring the matter to the DVO or by taking the fair market value as per the registered valuer. So the right course of action in the present case, the tribunal said that is to remit the matter back to the AO to determine the value of the tenancy rights by referring the matter to the DVO and then give the benefit to the assessee of section 54 or 54F as the condition satisfy. Friends, this case is very important because it gives a clear picture that first of all the tenancy right is a capital asset, its cost can be determined, and the right course to determine the cost of the tenancy right is to refer the matter back to the DVO. He will calculate by taking the various factors like the location of the property, the expected rent of that property, and the allied circumstances. At the end of this video, once again I am repeating the name of the case. The name of the case is Viral Chandresh Virvadia versus Income Tax Officer, and this case is reported in 138 ITR Tribunal at page number 36, and the date of the judgment is 25th March 2026. Thank you, friends.